Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903.
As a constitutional law attorney, former senior legal advisor, and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Hello, friends, and welcome to part 2 on the Jenna Ellis Show with my good friend Josh Hammer, who is the opinion editor at Newsweek and also hosts his own podcast on Newsweek called The Josh Hammer Show. Yesterday, if you missed that episode, definitely go back and listen to it. We're talking about Clarence Thomas and Justice Alito and the future of the Supreme Court. We got into yesterday more of the composition of the individual justices, the brilliance of Clarence Thomas. And now for this episode, I want to focus on the future of the Supreme Court, what we can anticipate from the next term or so, especially in light of the Dobbs opinion and that brilliant concurrence from Justice Thomas. And Josh Hammer, you wrote a great piece that in Newsweek that was asking that question: what is next for the conservative legal activists now that Roe versus Wade has been overturned? I mean, that has been a target for the last 50 years, and we're finally seeing this victory. So it's not time to just sit back and rest on that. Of course, we have to make these fights go to the individual 50 states, but even beyond the abortion issue, what is your opinion on the future and the focus that the conservative legal activists should now have?
Sure. So, Jenna, great to be back with you. So, first of all, before we get into that, I do think it's just worth spending a moment or two to emphasize how monumental of an achievement that this is. So, look, I've been a card-carrying member of the Federal Society since my first year of law school. I still do a lot of Federal Society talks at law schools, conferences, things of that nature. When the Federal Society, for the listeners who are less familiar, is kind of the organization most affiliated with the modern conservative legal project. It was founded in 1982. Really, since that organization's founding, and really kind of since the dissemination of originalism is kind of the default kind of principled kind of conservative libertarian jurisprudence, I would say overturning Roe versus Wade has been really kind of the goal of all goals. I mean, it has been hovering in the background now for 4 decades. I'm not going to say it is the only goal. That would be grossly overstating it. But Roe versus Wade and Planned Parenthood versus Casey and kind of getting abortion jurisprudence back in line has absolutely played an outsized role in the history of the modern conservative legal movement. So the fact that this Dobbs case actually happened, and also the fact, by the way, that they actually held the line, that they stiffened their spines and saw this thing through after an unprecedented leak, where I have to emphasize 2 months later, we still don't know the leaker, which I just cannot believe. I mean, that itself is another storyline that we cannot forget to just, that we can't forget about, because the leaker has to kind of face punitive justice, in my opinion. Mm-hmm. But look, all that being said, what overturning Roe and Casey and the Dobbs case does is return the issue back to the states. But from a pro-life perspective, obviously, from a perspective that views unborn human life as worth protecting under the confines of the American rule of law, this is not enough. It is a necessary precondition. It is a major step towards the just conclusion, which of course is an abortion-free America. But this is not necessarily the end unto itself. So, look, I'm born Jen on Abraham Lincoln's birthday. Lincoln's my favorite figure in American history. I think about kind of Lincoln's speeches and statesmanship a lot. As he said in Peoria, Illinois in 1854, he had a speech there where he said that the relevant question, this is obviously kind of as America is heading towards the cliff, the precipice of the Civil War. He said the relevant moral question when it comes to the question of chattel slavery is not whether the black man, the question is whether the relevant question pertaining to the black man is whether he is or is not a man, because from that answer, all the logical kind of things necessarily flow downstream from that. So a similar question, obviously, in the year 2022 is whether the unborn child is or is not a child. But we know the answer to that question, okay? And for the same reason that when Lincoln said in 1858 in his famous House Divided speech that this nation could not long endure, obviously, half free and half slave, so in the year 2022, I think pro-lifers should strive for an outcome that is not necessarily one where the unborn child's fate will be one in Texas or Oklahoma, but then will be an entirely different outcome in Oregon or California. That is not a just outcome for the long term. So moving forward, I think the pro-life argument has to shift a little bit and has to look something similar to what I and some others have been saying for a few years now, which is advancing kind of a legal and a policy claim. They're simultaneous, both claims, that the 14th Amendment's Equal Protection Clause, when it speaks of persons, actually includes all natural human beings, which actually includes unborn children. So that is kind of the next line, I think, of jurisprudence from a originalist conservative perspective in this category. And that's kind of what I was talking about a little bit in this column as well.
And so, we've heard different arguments from, those that are advocating a federal ban on abortion, using that language in the 14th Amendment and talking about, an incorporation doctrine sort of analysis. And then some who would say, well, because the Dobbs case very clearly constitutionally gave this issue to the 50 states, we can have that diversity just like we would on, some other issues that are given to the states that do have a diversity of state home rule on that particular issue. And so what's your perspective on having those 50 laboratories of democracy that can have a different rule on abortion versus some of these arguments for a federal rule?
So it's worth noting that the Alito majority opinion in Dobbs actually almost gets us halfway there. It almost gets us halfway to the conclusion that I kind of just said in my prior answer, and I say so because the line that Justice Alito uses over and over again, where he distinguishes Roe versus Wade and Planned Parenthood versus Casey, even from the other substantive due process cases, even when he's trying to contrast Roe versus Wade and Planned Parenthood versus Casey, even from Griswold versus Connecticut, even from Lawrence versus Texas, even from Obergefell versus Hodges, the court says that the reason that this case is different is because it involves the destruction of of what some people refer to as fetal life, some people refer to as potential unborn life, and some people, including the state of Mississippi, which obviously argue the Dobbs case, what refer to as an unborn human being. So he actually takes us halfway there because he literally makes a legal distinction. Put in other words, he makes a legal distinction, a doctrinal distinction within the bucket of substantive due process cases between Roe and Casey and the other substantive due process cases on the idea that the destruction of either a potential or a fully formed unborn human life is involved here. So I think he kind of takes us halfway there already. The next step from a pro-life perspective, legally and from a legislative perspective, is just kind of finish the thought. Now, look, I understand the argument, obviously, laboratories of democracy, 50 states there. I think for a lot of ideas, maybe for like health insurance, maybe for like tax policy, for income tax, capital gains tax, for a lot of things like that, that probably makes a lot of sense. It probably is worth bearing in mind, though, that the laboratories of democracy line does come from Louis D. Brandeis, kind of an iconic progressive. In fact, going back to Lincoln, who I mentioned, in the previous answer, Jenna, Lincoln obviously famously dueled in 1858 when he was running for Senate in Illinois with Stephen Douglas. And Stephen Douglas over and over again made a similar plea. He made a plea to resort to what he referred to as quote unquote popular sovereignty, which basically meant that the people of each state could just vote up or down how to treat the question of slavery. But Lincoln's point, kind of that Peoria speech that I mentioned last time, was that actually does not answer the question, because there is a moral truth. There is kind of an anchoring principle that kind of cuts to the heart of the matter. Then it was whether the black man is or is not a human being. Here it is whether the unborn child is or is not a human being worthy of protection under the rule of law. And the argument that Lincoln made, and then I and some of my my colleagues in this space are advancing now, is that the answer to that question has to be kind of the guiding principle for pro-lifers, both in state capitals and kind of making legal arguments to the federal courts in future years, not necessarily kind of this appeal to laboratories of democracy. But I do agree that obviously many issues are best decided under a constitutional order at a state level. The final thing that I'll say is, because I and some of my others friends in this space are focusing on the equal protection clause of the 14th Amendment, it does not actually entail substantive due process or incorporation doctrine at all. It's actually just a straight equal protection clause claim. At least from my perspective, it does not involve the due process clause at all, which is obviously getting into murkier areas from an originalist perspective.
Yeah, and I think that's wise to differentiate those particular arguments, because I hadn't heard up until now more of an equal protection analysis, at least in this vein. It was more of the substantive due process and incorporation types of arguments, which I don't know that those are particularly originalist, and they're particularly wise, especially when we look at some of the pitfalls of the incorporation doctrine, and some of that I think was taken out of context in substantive versus procedural due process. Which for those listening, if you heard the podcast last week with my good friend Mike Donnelly, who is an adjunct professor at Patrick Henry College and teaches constitutional law, we had a great conversation about those distinctions. And so if those two terms are something that you're not quite familiar with, go back and listen to that podcast. We talked very extensively about that. And, this is one of those great things, Josh, about how, we need to continue to have these conversations, and we need to continue not just as lawyers talking about these things and legal analysts, but also individual conservatives who are going to be making these arguments at the state level, who want to be involved in pro-life initiatives. You can't just be involved and say, well, I'm pro-life because, this is what I fervently believe from a faith-based perspective. That's not really going to get you very far in terms of a legal analysis. And you don't have to be a lawyer to understand a lot of these arguments and to be able to effectively be an advocate for pro-life. But you are going to have to do more than just have a lot of passion for an issue, because I think a lot of people who are influencers, activists, advocates, and they really want to put forward what they sincerely believe as a policy position or even as a legal outcome. Passion is no substitute for knowledge and for having a really consistent argument and a very well thought out rational opinion. And so as we're looking at some of these conservative issues, obviously pro-life is going to be a really, really big one. Where do you see the conservative legal landscape going apart from the pro-life issue? And now that this has been a huge win, and obviously we need to continue that and not saying, okay, well, now we can put that aside. But in addition to that, what are some of the other wins that we should be seeking?
Sure. So, yeah, this column that I wrote most recently. So the overarching point that I'm making here is whether it's abortion or kind of public religion, because we had, in addition to Dobbs and the Bruin case out of New York, there were huge wins for religious liberty this term as well. There was a case called Carson versus Macon out of Maine, and the Coach Kennedy case out of Washington State, which basically had the effect of really kind of firming up the idea that the Establishment Clause and the Free Exercise Clause in the First Amendment are not in tension. They should not be read as being at loggerheads or in any degree of tension with one another. Rather, they're supposed to buttress one another. It's a very kind of commonsensical point that Justice Gorsuch makes in the Coach Kennedy opinion, but it nonetheless is one that has been forgotten by 50 years of jurisprudence, because the Warren and Burger courts of 50 years ago or so, including a case called Lemon versus Kurtzman from 1971, basically had the effect of weaponizing the Establishment Clause to discriminate against the faithful and religious people in general in favor of secularism in the public square. So I say all that as context, because whether it is kind of overturning Lemon, which the Coach Kennedy case does, or overturning Roe and Casey, which the Dobbs case does, the net effect of some of these kind of culture war cases, for lack of a better term, is simply to get us back to a state of neutrality. It's simply to get us back to kind of the status quo ante of kind of a true kind of neutral playing field. But the point the somewhat provocative point that I was trying to make in this column, and I try to be nothing if not provocative, because I kind of just enjoy stirring the pot a little bit, the point that I was trying to make is that neutrality is an uninspiring end goal. I mean, as conservatives, from a political kind of movement perspective here, if I were trying to kind of fire up the proverbial troops, fire up the base, and say that, well, we are fighting for an equal playing field, we're fighting for live and let live. Well, that's not particularly inspiring, right? What we should be fighting for is some idea of victory, is some idea of a public square where kind of religion, tradition, conservatism actually reigns supreme. And that's not to say that there should not be room, obviously, for dissenting viewpoints, but it is simply true at the time of the American founding, to kind of give one example there, that some idea of ecumenical Christianity in particular was directly intertwined with the idea of kind of a public facing America. This idea of separation of church and state, which kind of comes from an 1802 Thomas Jefferson letter, a 233-word nothing burger letter that he wrote to the Danbury, Connecticut Baptist, that is totally ahistorical nonsense. So to give one example, I think I mentioned this in the column, from a public religiosity perspective, I think conservative litigators should be trying now to overturn a 1947 case called Everson, which is the first time that the court actually injected the rhetoric of separation of church and state into the Supreme Court reporter. So that would be just one possible example of what not necessarily neutrality, but what victory would actually look like, because the direct effect of that would allow us to kind of have more public religiosity in the public square, perhaps even eventually get the Bibles back in schools once we could overturn a post-Everson case called Engel versus Vitale. So that's kind of what I have in mind here. I mean, I think neutrality, now there's kind of emphasis on kind of the legal conservative project as being anchored in neutrality and really kind of legal positivism, to be totally honest with you, that has gotten us now to a very, very good point. This is the best term in the modern history of the conservative legal project. I'm just trying to now kind of sketch the guidelines for what a kind of more forward-facing and admittedly more assertive and perhaps aggressive agenda going forward might actually look like.
Yeah, and I think that's entirely appropriate, especially within this context and landscape. And, a lot of the conservative views like this do go back to the founding and to history, where the progressive notion is wanting to completely unanchor ourselves and to completely revolutionize and reimagine, if you will, a better America. And they're wanting to completely change the meaning of not just basic terms like man versus woman, but all of these other terms that are actually embedded in the Constitution, and ignore those completely. And what we've seen over the last even 100 years of American jurisprudence is taking these words and phrases and these terms and these clauses out of context and building an entire jurisprudential doctrine around them that is just advancing a particular outcome rather than the plain meaning of the Constitution, the plain meaning of what our American founding was all about, and why we are giving specific limited powers to our federal government to operate, to preserve and protect our rights, which the founders acknowledged in the Declaration that we just celebrated this past weekend, come from God, our Creator. And so to say that somehow there should be a separation of church and state, or that we can't advocate for why we are a Christian nation, in the sense that biblical morality and this understanding of objective truth and our rights coming from God, our Creator, not our government, not collective man's judgment, those are all inherently Christian ideals, and they are the morality of objective truth. And if we don't get our morality and our self-evident truth from either the view of reality or from God, our Creator, in a biblical worldview, we have to get it from somewhere. And what the progressives have done is exactly what you're talking about, Josh, which is trying to just get this back to either neutrality or this idea that everything is inherently amoral, that it's not either moral or immoral, and we can't make those designations or have a measurable difference between right and wrong and good and evil. It's just what I perceive and I feel and I think versus what you think and you feel and you think. And we should somehow be able to coexist in this whole diversity of a landscape where it's completely fine if, in my view, I want to have these religious opinions, but in your view, you want to have some completely different view of morality. That doesn't really work when we're coming to even an equal protection sort of doctrine, going back to your argument with Dobbs. It just doesn't work when we have to have a functional view of law and law enforcement and equal protection of the law and having a supreme law of the land. So I think you're completely spot on when you're saying we need to go beyond just this neutrality view, because neutrality has been really in more of a philosophical angle, viewed as just everything in law itself should be amoral. But that's completely inconsistent with the very definition of law. So how do you think that we can, as conservatives, best advance that viewpoint, not only in courtrooms, but also just in the public square and culture?
So it's very well said, Jenna. Yeah, I do think that neutrality has kind of an end unto itself, has had the unfortunate byproduct of being kind of a one-way ratchet towards progressivism, and it really is kind of time to now think a little more outside the box and more assertively about what comes next. Look, on a selfish note here, I mean, not self on a self-aggrandizing note, I've done some kind of some work over the past couple of years trying to chart out what a jurisprudence that what I refer to as common good originalism might look like. It's a distinct theory from Professor Adrian Vermeule's common good constitutionalism, which is avowedly non-originalist. Mine is originalist. It is just kind of originalism with kind of a more assertive, moralistic sense of where it fits into kind of the transcendental order of things. So I would encourage listeners and viewers of this podcast to check out that essay. I think Jenna, we did a long special on this last year. Actually, at the time that I wrote it, I published it at the Harvard Journal of Law and Public Policy. So go ahead and check that out, especially if you're kind of legal nerd or kind of inclined towards legal nerdery. You might enjoy it there. But
or civic nerdery, even.
Yeah,
we all should
civic
be civic
nerdery,
nerds.
exactly. Yeah, no,
Yeah.
totally, right. If we want to kind of do what Tocqueville once told us to do and kind of just be like good lowercase r Republican-minded citizens, right? But look, from a kind of a citizen perspective here, one thing that I would encourage, legislators, citizens, just activists in general to do here for decades and decades, right? And this is kind of imbued in kind of the separation of church and state, neutrality kind of paradigm. I think conservatives, traditionalists, and religious and social conservatives, perhaps in particular, we're told that you can't advance like moralistic arguments, right? You can't advance public policy arguments that are clearly kind of derived from Judeo-Christian principles, because then you would be violating establishment clause, separation of church and state. This is such profound nonsense. In fact, in my Newsweek podcast episode out this week, where I did kind of a Supreme Court kind of term in review special, we actually play a soundbite from a Senate speech that no less a progressive than then Senator Barack Obama gave back in 2006. And it's really remarkable to hear. He basically says at the time that it's crazy to tell people that they can't bring their values into the town square. He even kind of uses the word secularist in actually a deriding manner to like refer to kind of people left of center. You would never hear a liberal today referring to secularists in kind of a condescending term. So just kind of shows you how far the culture has gone just in the past 16 years, actually. But the idea here is that we have to be untrammeled. We cannot hide the fact that our moral logic, our logical reasoning derives from certain first principles, and those first principles are ones that come from a biblical worldview, a Judeo-Christian, Jewish or Christian worldview. And there is absolutely nothing whatsoever wrong with that. So ultimately speaking, lawmaking, legislation, jurisprudence, ultimately all of these things are inherently, to one degree or another, moralistic enterprises. Obviously, legislation can be more forthrightly moralistic. Jurisprudence is a little more complicated. That's kind of what makes it fun from my perspective. But when we're talking about kind of lobbying state legislators or state legislating, you should be thinking about how to legislate morality, and specifically trying to how to kind of advance a moralistic agenda to bring us back more in line with how the American founders conceived this nation. And the way that they conceived this nation can be kind of summarized by this famous quote from John Adams, right? John Adams famously said that the Constitution was made for a religious and moral people. It is wholly inadequate to, it's wholly inadequate for any other. So, and to put another way, if we are not religious and moral people, the Constitution's not for us. And I think that whether you're a judge, a jurist, or a lawmaker, or a lobbyist, an activist, whatever, that is what you have to bear in mind when we think about how to go about the next steps of this entire project.
Yeah, and I think that one of the most profound points that you've articulated during this episode, Josh, is that the originalist view and the conservative posture towards the future of legal battles needs to be more on the offensive, and we should not take this view that conservatism or conserving truth is always by definition defensive. And I think we've taken that and kind of put that into our common parlance or our views that we just need to defend truth, and that's it. And we can't go on the offensive. We can't seek to codify our views into law, because that would somehow be violation of separation of church nation state or somehow imposing my morality. And we're borrowing a lot of these really nonsensical ideas from the left that are really handicapping and crippling us from actually advancing what our founders gave us through the blessings of liberty and the recognition that law and policy is and always will be inherently moral. And that is just true looking at the very nature and definition of how a government operates in civil society. And this contrasts with a libertarian view that government is, by definition, almost always inherently evil and should only serve very limited purposes to just arbitrate contract disputes, and everyone should be free to pursue their own view of morality. That's just a very not only impractical but also nonsensical definition of the purpose of government and how government does actually move in society. Because even if you go with the non-aggression principle and harm and some of those things, harm by definition is a moral term, because if you are saying I am perpetuating a harm against someone else, harm in and of itself means something that is immoral. That is something that is a wrong. It is a an offense against another person. And so when law touches and concerns all of these topics, it's just inescapably a fact that law does carry with it the weight of morality. So just whose truth then are we codifying? And the left has been very, very strong at trying to codify their own view of morality, their own truth, and they have been unabashedly advocates for this. And they're trying to relegate us as conservatives to this position of just neutrality, where we then are too timid to say, no, this is what we're standing up for. And it's not just because of my faith as a linchpin, it's because of self-evident truth. It's because of how law is designed and functions. My faith does inform me, but that doesn't mean I can't make these overt attempts to try to codify morality, whether it is on the state and local level or the federal level, obviously according to the principles of limited power as well. And so I think that's a really, really important point that people can take from this, that conservatism is not just defensive. We have to go on the offense, and we have to unabashedly stand up and say, this is truth based on science, all of these other things based on morality, and have a well-reasoned position for doing so. So as you're looking at the composition of the Supreme Court that we talked about in yesterday's episode, where do you think that conservatives with these arguments will be the most effective? On the state and local level? I mean, obviously not in places like California and New York, or the federal level, looking at, what Congress may look like in the midterms. Should it be that we're focusing on all of these? And I know that you've written that great piece on common sense originalism and, all of these things in the common good. People should definitely read all of your work and, see where they agree and disagree with it. But where do you think that we can advance this the most?
I think that all of the above strategy is more or less called for, certainly. I mean, just take one example. I mean, the abortion issue is just it happens to be like a very easy example to do here. So, on that issue now in a post-Roe, post-Dobbs abortion regime, we need to be obviously working at a state level, state by state, state legislature by state legislature to protect life, while simultaneously, we should be looking for a case that ultimately could get litigated to the Supreme Court that would allow kind of this 14th Amendment Equal Protection Clause argument to be made. While at the same time, we probably should be working, whether in the states or in Congress, ultimately, ideally, to ultimately pass an amendment to the U.S. Constitution, a human life amendment, which is actually, if I'm not mistaken, I think it's been part of the Republican Party platform now for 40 years. So that's really nothing new. That's been around since quite literally the Reagan administration, if I'm not mistaken. But, the other thing also is that from a congressional standpoint there, Section 5 of the 14th Amendment, a lot of people don't realize this. Section 5 of the 14th Amendment actually allows Congress to enforce the terms of Sections 1 through 4. And there's a lot of literature from the time of the ratification of the 14th Amendment in 1868, from folks like John Bingham, the congressman from Ohio, who was a leading draftsman of that provision of that amendment. There's a lot of evidence suggesting that the framers and ratifiers of that amendment intended for Congress, not necessarily the courts, but Congress, to actually be the leading enforcer of those provisions. There was a case out of Texas called City of Bernie versus Texas in 1997 that it's a very difficult case. It's kind of in the legal weeds. I mean, it might have kind of taken away Congress's ability to enforce Section 5 a little bit there, but there's still a lot of utility left in Congress's Section 5 enforcement power. So to kind of break away from the legalese, what I'm trying to say basically is that if Congress wanted to actually legislate a national abortion ban tomorrow by invoking Section 5 of the 14th Amendment to enforce this understanding of the Equal Protection Clause, they could do so. So, that's something that activists could literally be calling up their congressman or senator to introduce them over the phone tomorrow. But for the time being, I think focusing on a more local, state by state level is probably the best path forward. But again, whether the arena is jurisprudence, whether it's kind of the good old Bismarckian sausage making process of lawmaking itself in the state capitals and in Congress, we have to be willing to kind of go on offense, be willing to actually now assert our morals, because the fact that Roe and Casey are overturned quite literally permits us to do that. They have given us the freedom that that 50 years of religious and social conservatives have not been able to do, which is to kind of make profound, untrammeled moral argumentation in the public square. So, that doesn't necessarily mean that it would be prudent or wise to go to our interlocutors on the other side and say that they are kind of atheistic, pagan, baby-killing murder. No, that's obviously not how hearts and minds are persuaded, obviously. So, we should be kind of Reaganite in terms of kind of our optimistic, happy warrior nature, but it should free us to be more confident in our convictions and more confident in the fact that our convictions cannot just be swatted away by these spurious citations or invocations of separation of church and state or something like that.
Yeah, very, very well said. Well, Josh Hammer, thanks so much for joining me over these past 2 days. This has been really informative, and I'm so excited to see the future of the Supreme Court and also the future of not only the pro-life argument, but also conservative activism in the legal square and also in all of these particular debates, and how we can advocate for originalism and for conservatism and ultimately for the truth of morality. And so, again, where can people find you, your work, your show, The Josh Hammer Show, which is a podcast off of Newsweek, all of the things that you do, and you're just as busy as I am, I think. And so you put out a lot of great content, and probably more than I can consume every day, but I always try to read and listen to everything that you do. So thanks.
Well, that's very kind of you, Jenna. Yeah, so the listeners can go ahead and check me out at on Twitter. I'm Josh_Hammer. My podcast, The Josh Hammer Show, is on Apple Podcasts or Spotify. And then, of course, I also edit the Newsweek op-ed section every day, along with my 4 deputy editors. So we're at newsweek.com/opinion for that as well.
All right. Well, thanks so much, and look forward to talking with you soon. Thanks.
Okay. Take care, Jenna. Thank you.
Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. I also want to talk about another great American who is the sponsor of this podcast, and that, of course, is my good friend Mike Lindell. He has been canceled out of so many box stores for simply standing up for his own political opinion. And disagree or not, or support him or not, It is a fundamental right of every American to be able to voice their opinion, and that absolutely includes politics. That absolutely includes issues that are central to our culture. That includes faith. Mike is such a very sincere Christian, and I am proud to consider him a friend, and he is, of course, a friend of this show. So right now, there is a special on MyPillow.com. Click on the new radio listener specials. Get deep discounts on all MyPillow products, including a great towel set, which is a 6-piece set. It includes 2 bath, 2 hand towels, 2 washcloths, made in the USA, regularly $109.99, now just $39.99, but you have to use the promo code Jenna. That's Jenna. That tells Mike that you listen to this show, you're happy that he is a sponsor of this show, and you will get great discounts, but use the promo code Jenna, that's Jenna, either at mypillow.com or call 1-800-564-8475 and use the promo code Jenna.